here's the next question from Andante 423. Thanks, Glenn. Will the rule, I don't know what, thank you. Will the ruling blocking the AEA in South Texas do anything to help the people who were already sent to El Salvador, the Cesset prison in El Salvador? So just to fill you in on what that person is asking about, it's a great question. Thank you. Just to give you the context, because it's so important. All of you, of course, remember when Trump ICE picked up 238 Venezuelans and then just in the middle of the night shipped them out of the United States on a plane to El Salvador prison, and they filmed these people being dehumanized, being humiliated, having their heads shaved, kneeling on the floor. And it's almost certainly the case that at least some of them weren't actually guilty of being gang members, but they're in this prison that's designed to be permanent. It runs on slave labor. It's one of the most abusive ones. But when this got to the Supreme Court said by a 9-0 ruling, so that includes Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh, all of the conservatives' favorite judges, by a 9-0 ruling, it said, even if you want to use the Alien Enemies Act, you still have to give these people a due process. You have to give them a hearing, advance notice of their intent to be removed, and then their opportunity to go into court and present evidence that, I'm not a gang member. This is a tattoo they use. This is an autism tattoo, or this is a tattoo celebrating my family, or whatever. So they already said you have to give them a court hearing. And in this court hearing, the judges should decide two things. Number one, does Trump have the right to invoke the Alien Enemies Act? It's supposed to be a wartime statute. It's only for wartime. The only 3 times it was invoked previously was the War of 1812, World War I, World War II. And just to give you a feel for how extremist this power is, that's what FDR used to order all Japanese Americans interned in concentration camps on the grounds that they were suspect to be loyal to Japan. Generally considered one of the most shameful acts of the 20th century. But at least there was a real war going on in World War II. Trump's theory is that we're at war with Trinidad, or it constitutes like an invasion, which is not what any war has ever looked like previously. And so the Supreme Court said it's dubious if Trump can invoke it at all, and the court should decide that. But then even if he can, you have to have a hearing on whether these people are really alien enemies, whether they're members of violent gangs. They need to have an opportunity to contest it. So they sent it away from Judge Boasberg. They said it can't be in D.C. It has to be where the prisoners are held. And they're purposely keeping the prisoners in Texas, believing that, which is true, most of the judges in Texas are right-wing Republican conservatives, and believing that they would get better judges. And they did. They got it when the lawyers for the Venezuelan detainees sued in federal court to argue that this law was invalidly invoked and that they weren't gang members. They got the best judge they could have gotten. They got a judge appointed by Donald Trump in his first term. So he's a Trump-appointed judge. And you can imagine how conservative judges are who Trump appoints from Texas. Whole state's red, governor's red, 2 senators are Republicans. And yet that's the judge that yesterday said that there's no legal foundation for adopting and invoking the Alien Enemies Act because we're not actually in war. Here's the New York Times article on the ruling. Federal judge strikes down Trump's use of Alien Enemies Act to deport Venezuelans. Quote, a federal judge on Thursday permanently barred the Trump administration from invoking the Alien Enemies Act, an 18th century wartime law to deport Venezuelans it has deemed to be criminals from the Southern District of Texas, saying that the White House's use of the statute was illegal. The decision by the judge, Fernando Rodriguez Jr., was the most expansive ruling yet by any of the numerous jurists who are currently hearing challenges to the White House's efforts to employ the powerful but rarely invoked law as part of the wide-ranging deportation plans. The 36-page ruling by Judge Rodriguez, a President Trump appointee, amounted to a philosophical rejection of the White House's attempts to transpose the Alien Enemies Act. In the Alien Enemies Act, it says this statute can be invoked when we're at war. So the Trump administration had to concoct a theory. How are we at war? Who are we at war with? And their argument was, we're at war basically with these international drug gangs that are invading our country. They're like an invading army. We're not at war with any specific country, just like a group of criminals. And here's the ruling from this Trump-appointed judge issued yesterday. There you see the caption. It is JAV, which is one of the Venezuelan detainees that they want to deport, versus Donald Trump. I'm going to read you some of this case just so you can get a feel for the ruling. Probably not as much as we planned because it's quite long, but it's not actually a long opinion. You can read it. We'll put the link in the notes, but it says this, quote, "Neither the court nor the parties question the executive branch's authority and responsibility to enforce federal laws, and along with local law enforcement agencies to protect the nation's population. Neither the court nor the parties question that the executive branch can direct the detention and removal of aliens who engage in criminal activity in the United States. The executive branch has and will continue to rely on the Immigration and Nationality Act to remove aliens found to represent a danger to the country. The question that this law presents is whether the president can utilize a different statute, a specific statute, the Alien Enemies Act, to detain and remove Venezuelan aliens who are members of Nicaragua. As to that question, the historical record renders clear that the president's invocation of the AEA through the proclamation that he issued exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. As a result, the court concludes that as a matter of law, the executive branch cannot rely on the AEA based on the proclamation Trump issued to detain the named petitioners in the certified class or to remove them from the country. The AEA grants broad powers to the president, who may invoke the statute when, quote, a declared war exists. A declared war. The only body that has the power to declare war is the United States Congress. And needless to say, they didn't declare war here. The statute says when a, quote, declared war exists between the United States and a, quote, foreign nation or government, or when, quote, any invasion or predatory incursion is perpetrated, attempted, or threatened against the United States by any foreign nation or government. Under either condition, the president must, quote, make public proclamation of the event before exercising his statutory authority under the statute. Once properly invoked, the AEA renders, quote, all native citizens, denizens, or subjects of the hostile nation of the government and who are at least 14 years of age within the United States and not actually naturalized, quote, liable to be apprehended, retained, secured, and removed as alien enemies. And again, that's what allowed FDR to say, I'm using the Alien Enemies Act to take all Japanese Americans and just detain them until the war's over. No due process, none of that. On March 15, 2025, President Trump issued the proclamation at issue in this lawsuit. No president has invoked the AEA other than during a time of war, including the War of 1812, World War I, and World War II. The proclamation makes no reference to and in no manner suggests that a threat exists of an organized armed group of individuals entering the United States at the direction of Venezuela to conquer the country or assume control over a portion of the nation. Thus, the proclamation's language cannot be read as describing conduct that falls within the meaning of, quote, invasion for purposes of the AEA. As for, quote, predatory incursion, the proclamation does not describe an armed group of individuals entering the United States as an organized unit to attack a city, coastal town, or any other defined geographical area with the purpose of plundering or destroying property and lives. The court concludes that while it may not adjudicate the veracity of the factual statements in the proclamation, or the propriety of the steps taken by the president to add Venezuelan aliens and Nicaragua members, this court retains the authority to construe the AEA's terms and determine whether the announced basis for the proclamation properly invokes the statute. And it goes on with language explaining why, based on the history and the language of the statute, the president cannot invoke this law. Because it's only for wartime and we're not at wartime. It's as simple as that. And I've seen a lot of conservatives kind of questioning, like, why did the courts get to decide this? In part, it's because that's been how the Supreme Court and the judicial power have been interpreted for more than 200 years, going back to Marbury versus Madison. And if you think about it, it has to be this way. The purpose of the Constitution is to limit the powers of the federal government, to limit the powers of the president and Congress. Like the government can't do this, it can't do that, it can't do the other thing. So if the president ignores the Constitution, let's say Joe Biden orders that all Trump supporters be rounded up and imprisoned with no trial, obviously a violation of the Constitution. If you can't go to the courts and seek relief and ask the courts to declare that unconstitutional, who does that then? Like, where do you go? Where do you get relief? And the president just starts ordering his political enemies imprisoned with no trial, no due process. Of course, it's the courts who have to say, this is unconstitutional and therefore it can't be done. Or if the government invokes some sort of statute that Congress passed, like the AAA, and the statute says the government can do A, B, and C as long as conditions 1, 2, and 3 prevail. But instead of only doing A, B, and C, the government also does D, E, and F. Even though the conditions, the 3 conditions that Congress required, don't actually exist. They're just totally misusing a law. Who do you go to and to say this is illegal based on the law Congress passed? Of course, you go to the courts. That's how our system works. And it's all balanced. It's not like the courts are the supreme branch as sometimes people try and claim. It's the president who appoints the judges who are on the courts. Congress or the Senate has to confirm them. And then if they start abusing their power, they can be impeached. And federal court judges have been impeached before. Not often, but they can be, and they have been. And then on top of that, the courts really have no way to execute their decisions. They don't have an army, they don't have guns, they don't have any way to force a president. The president or a Congress basically respects the credibility of the courts, and that's why court decisions are abided by. So that's how there's no way to argue the Supreme Court or the courts in general are supreme. President has all kinds of powers, the Congress has all kinds of powers. But if you're going to have a constitution and a set of laws, you need to have somebody who interprets what those are and who decrees what they are. And you can't ask the president to rule in his own case, like, hey, Mr. President, are you violating the law? Are you violating the Constitution? And obviously tons of conservatives, many times, under Clinton, under Obama, under Biden, ran into court and asked federal court judges to put a stop to what those administrations were doing. Now, it is true that there are a lot more of those rulings coming under Trump, and you could make the argument that's because he has so many different new policies that have tested and pushed the limits of law. But that's how our system works. It works that way under every president. And I do think picking people up in our country and sending them for life in prison in a country they have nothing to do with and have never been to, where they'll never get out, is an absolutely extremist power, and we definitely need judicial review. And as the court said, the president, even despite not being able to use the Alien Enemies Act, has all the legal authority in the world to deport people who are illegally in the country. That's the other set of laws, the Immigration Nationality Act and others. That's how President Obama deported millions of people. He didn't use the Alien Enemies Act, he used the set of laws that are normally used for that. And that's what the court is saying. Doesn't mean you can't deport people in the country illegally. It's your obligation and your right and your duty to do that. You just can't use this wartime power to do so because we're not at war as the statute describes it. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.